baby, got another one. Jump on it, jump on it, jump on it. Jump on it, jump on it.
Jump on it, jump on it. Ride it like taxes in hell, smoking that loud, lace the yak with mouth. Make your mama proud, popping it like shot. Turn up, it's a gangster party.
PT ain't never popped a Mari, but if I ever catch Mac, I'ma pop a Harley. I don't even rob a cop the Harley. Blowing so much green, I shame Marley. Yeah, I push the line to its full limit. Hit the hole like 22, boy, I'm a young Emmett. Nothing go like snow, now that's a cold image. Still whistling, sending, knocking them white women. Only reason I do it to avenge image. To the day they go before and they box me out. Knowing me, it don't matter, I simply change my route. On my hobby.
Where's? Welcome to the DAMU KIWE Conversations, home of the West Coast, voice of the culture. It's Deuce Sims the Don. I'm right back at you just like a crack addict. You know what I'm saying? We got the content. Now, I apologize to everybody, man. Let me start off first. All independent hip-hop rappers, tap in and let me show y'all this real quick. All independent hip-hop rappers, tap in, and all content creators, tap in, right? I want to make sure that y'all aware of what we got going on and that y'all come get a bigger bag over here with us, you know what I'm saying, at Hip Hop Planet. So you dig? Let's see how that thing looking. Y'all see that thing? Y'all see that thing? Hip Hop Planets, man. This is what we on. You know what I'm saying? Do y'all see how much we talking about? Let's get down to it though. The solution. Are we gonna have that bag? Is you trying to get a piece of that bag? You know what I'm saying? Is you trying to get a piece of that bag? Look at this. That's the mall, Planet Akabuyan. You know what I'm saying? 470 million unclaimed. Intergalactic super mall where you'll be able to shop, set up shop. All businesses can have their own merch. In AR, you'll be able to shop like you actually walking through the mall. And you'll be able to open up stores if you're trying to get the bag. Use funds. $4 million seed round, go-to market, MVP development, 40% of that, engineering, creator onboarding. You guys are going to get paid. You know what I'm saying? We're going to bring some big creators over there, some small creators too. You know what I'm saying? With the little chump change we get up out of that. You dig? You know what I'm saying? Raising $4 million seed round. You know what I'm saying? There go Hip Hop Planets. You know what I'm saying? Well, we gonna offer the service of how to protect your rights. So I've been working on this and having meetings all week with investors and sponsors. You know what I'm saying? And I passed out last night, bro, on the couch. I didn't even make it to the bed. You know what I'm saying? And Maria left me alone. She knew how tired I was, going to sleep at 3, waking up at 5:30. You know what I'm saying? And then here goes the data room, the investor data room. You know what I'm saying? Investor overview, company, product, market, competition, technology, traction, financial, strategic partnership, corporate sponsors. If you work for a major corporation that want to be one of the founding fathers, tap in. You know what I'm saying? What we do got is for corporate sponsors, we have the founding brand partner proposal. Hip Hop Planets is building an immersive creator ecosystem, combining live stream music events, fan engagement, and virtual commerce. This proposal outlines strategic partnership opportunities for brands seeking authentic engagement with hip hop culture and creator communities inside the Hip Hop Planet's digital universe. Platform Akabuyan is the creator rights engine. I'm telling you, We gonna fix that problem where your money ain't going to black box. We gonna help you register your shit. It's real complicated, but we gonna come fuck with us. We got you. Creator right engine enabling artists to register music and control their intellectual property. You'll own your own masters. Club Noir, rest in peace, Nipsey Hussle. Immersive live stream venue for concerts, DJ events, and cultural programming. Intergalactic supermall virtual shopping environment where brands operate digital storefronts. Found in brand partner opportunity, permanent storefront presence inside the Hip Hop Planet Supermall, because you do have to pay virtual rent inside the mall. But not if you're a founding brand partner and you come with that bag early. We gonna give you a long time without having to pay. Sponsorship of live stream concerts and cultural events, creator collaboration campaigns with artists and influencers, product placement during live stream performances, and branded digital experiences and marketing activation. Partner, you got to spend $250,000 to a million. Launch partner, $100,000 to $250,000. Event sponsor, $25,000 to $100,000. That's for live stream concerts. The launch partner, brand activations, creator collaborations, founding cultural partners. They give a quarter to a ticket. Then they'll get permanent mall storefront, major event sponsorship. Strategic alliance framework. And so y'all can tap in if you're an executive for a major brand. You know what I'm saying? You tap in. We can get this bag together. You know what I'm saying? So that's just one thing y'all could tap in for. But I've been so busy with that I've been exhausted, man. You know what I'm saying? That grind is serious. You know what I'm saying? See, I was that nigga that was on the block that pull all-nighters. You know what I'm saying? But so I fell asleep. Apologies to y'all. Y'all deserve better professionalism. But I got to go to where the bag at. And y'all act like y'all don't even be want to hit the like button. Bang that like button. We got the content. You know what I'm saying? So, Big U draws. Hannibal. Eugene Henley Jr. Don't do it. We die. Not right here. My family's right here. You know? So he defended Henley request for reassignment of consideration of suppression motions to a different district court judge. So he don't want this judge that he got to rule on a suppression motion for some reason. We're going to get into that. You know what I'm saying? This was filed February 27th, so it's been about a week. Well, a little over a week, maybe 28, and today is the 6th, so 7 days. 7 days ago, Big U lawyers filed this. Defendant Eugene Henley. Oh, y'all see the stamp from the court? Where's the stamp from the court? Maybe it's at the bottom. Defendant Eugene Henley, by and through his counsels of record, Craig Harbaugh and Peter Johnson, hereby request that the court reassign to a different district judge Mr. Henley's pending motion to suppress intercepted communications, ECF number 194, as mandated by the U.S. versus Rodriguez, 9th Circuit, 2017. The defense further requests, in the interest of judicial consistency and economy, that Mr. Henley's motion to suppress evidence obtained as a result of search warrants, ECF number 198, be reassigned to the same district judge. So he's for some reason, he don't want this judge to be ruling on these wiretaps, right? Introduction. On February 6, 2026, defendant filed 2 motions to suppress, challenging the legality of the government's investigation. One directed at the Title III wiretap authorizations and another directed at standard search warrants. Both motions raised substantial challenges under Franks versus Delaware, 438 U.S. 154, 1978 case. That's a Supreme Court case, which takes precedent even over the Ninth Circuit. In California, the Central District of California comes under the Ninth Circuit, the most liberal appellate circuit in the nation, alleging that the underlying affidavits contain deliberate and reckless distortions and omissions, because this court served as the issuing authority for the wiretap orders. Ninth Circuit precedent mandates that a different district judge review the wiretap suppression motion. So now that's the reason why the judge that he okayed these wiretaps, so they're asking that he recluse himself on those wiretaps he approved, and that another judge is able to rule on them. You know what I'm saying? So we definitely doing that. Nigga, you got to recluse yourself. That's a conflict of interest. Some of them judges don't want to be the ones to admit that they fucked up. You know what I'm saying? Bang that like button. Let's go. Furthermore, because the Franks challenges in both the wiretap and standard warrant motions rely on the same factual nexus, including the same confidential source, some of the same distorted events, and collaborative work by the respective affiants, judicial economy, and the interests of justice favor reassigning both motions to the same district judge. Argument. Ninth Circuit precedent mandates reassignment for the wiretap motion. The Ninth Circuit has established a clear procedural mandate. A different district court judge must decide any motion to suppress evidence, creating a second level of review in its district court. U.S. versus Rodriguez noted the twist in appellate review of wiretap suppression motions, which requires consideration of the orders of two distinct judicial actors, the issuing district court judge and the reviewing district court judge. That they cite U.S. versus Rodriguez Cartagena. Because a different district court judge must decide a motion to suppress wiretap evidence, Mr. Cabrera's motion to suppress was referred to this court. Let me read this footnote for you. The Ninth Circuit's unpublished decision in U.S. versus Carey does not undermine Rodriguez's mandate. There, the defendant raised the need for a different judge for the first time on appeal, and the sole issue raised. Now back to this requirement is a structural necessity. The need for particularity in evidence of reliability and a showing required when judicial authorization of a search is sought is especially great in the case of eavesdropping. Berger versus New York, another Supreme Court case, because the use of wiretaps is highly intrusive. So the law is set to put safeguards because wiretap is highly intrusive. As the Constitution provides us rights against intrusiveness into our privacy. So they have to meet a certain standard to get a wiretap, submit an affidavit, even submit the affidavit. And then the judge has to find whether or not they have this is necessary and why it's necessary. There's steps. Well, I'm going to go to my boy 504 at the end. He breaks that down anyway. So the referral to a different judge ensures that the critical decision whether to issue the wiretap in the first instant is subjected to independent scrutiny. See, it can't be the same judge ruling on it because it has to be independent scrutiny, right? The wiretap authorization often requires the same district court judge to fulfill ongoing supervision through extensions and periodic reports. Then they go on the USC subsection 2518.5, 30-day wiretap extensions. 18 USC 2518.6, interim reporting requirement, right? This is what they got to do for these wiretaps, given the sheer volume of material and the iterative nature of these authorizations, the Ninth Circuit's mandate for a second level review by a different judge ensures that the initial validity of the warrant is tested by a jurist who has not been previously immersed in the ex parte development of the government's investigation. The need for this independent review is particularly acute when the wiretap suppression motion involves a Frank's challenge. A defendant may attack an affidavit containing deliberate or reckless distortions, Franks versus Delaware, including omissions of fact that tend to mislead. So now his lawyers is talking to the courts and citing legal reasons why the Big U's actual judge has to send this to another judge to rule on the motion to suppress. And they're telling them, especially when omissions of facts that tend to mislead. Well, what in the wiretaps have they presented to the grand jury, or what in the wiretaps have they presented to the court that wasn't wholeheartedly true? If it's misleading, that means that they took something and ran a narrative of what it meant, as opposed to taking into context the entire conversation or wiretap. So this is what you can deduce just from what they're talking in this motion. By reporting less than the total story, an affiant can manipulate the inferences a magistrate will draw and denude the probable cause requirement of all real meaning. In evaluating the Frank's challenge here, the court will be asked to scrutinize not only the FBI's conduct, but the representations presented to this court and the inferences the affidavit urged the court to draw. In addition to evaluating the impact of the application omissions and distortions, the court would necessarily be required to revisit its own probable cause calculus, including whether certain interpretive leaps embedded in the affidavit were reasonable and material to issuance. Let me read that footnote. In his suppression motion, concerned information obtained after the issuance of the wiretap order, ID at 5, emphasis added, because the motion did not require the issuing judge to engage in a second level review of his own wiretap authorization. The Cary court concluded that reassignment was not required. ID here. In contrast, Mr. Henley directly attacks the validity of the wiretap, squarely invoking the Rodriguez mandate for an independent second level of review, right? For example, when Henley stated rob Peter to pay Paul while struggling to meet payroll for employees at his nonprofit organization, the affiant asked the court to accept his conclusion that this meant Henley literally intended to commit a robbery. Similarly, the affidavit asserted that is not what the fuck rob Peter to pay Paul mean. They told the court to accept the conclusion that he literally intended to commit a robbery. Rob Peter to pay Paul means, look, go ahead. I'm gonna go ahead and take this money out my pocket, and then because these kids need these helmets and this equipment, and we got that trip coming up. They got a football game. We gonna do that. You know what I'm saying? I'm gonna come out my pocket. But when Shaq come with some money or Draymond Green come with some money, he promised me that he gonna do it. He's good for it. Then I'll be able to pay myself because I'm already behind in my mortgage and everything because I'm dedicated to these kids. So that's robbing Peter to pay Paul, right? That's an instance. That's so prejudicial that they asked the court to accept his conclusion that meant he literally intended to commit a robbery, bro. Similarly, the affidavit asserted that confidential human source 1 and others asked Henley to rent his house where CHS1 lived, even while simultaneously portraying CHS1 as acting under constant fear and coercion. That is definitely, they're talking about Dale Morrison. Dale Morrison, so now they do got proof that Dale Morrison was written. The lawyers, y'all dumb truck ass lawyers ain't gonna be able to fuck this one up. Bam, 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 bam. Big U was leasing his apartment on Arlington, or his house on Arlington, to Dale Morrison, bro. I know multiple witnesses who first met Dale on Arlington at Big U's house over there. He was leasing. He's a bad paymaster, right? He robs Peter to pay Paul. Hey, look, man, you know, I'm running through about 30 pounds a week inside the dispensary, man. You know what I'm saying? I took a loss. You know, they robbed my thing, man. Front me like 20 pounds. You know what I'm saying? And I'm gonna get you back your money and this and this and that. So you front him some money. Now he owe you for the 20 pounds, and he takes the money from the 20 pounds to pay Big U's rent. The rent he owed Big U, and whatever else he owed Big U from the business that they had going down. That's rob Peter to pay Paul. Dale Morrison has so many as a promoter with the business, joint business that they got together, and then as a renter at his house on Arlington. But the affidavit asserted that he and others asked Big U to rent his house where CHS1 lived, even while simultaneously saying he's acting under constant fear and coercion. How was he in constant fear and coercion, and he's still doing business with him, and Big U ain't did nothing to him? He ain't beat him up. He ain't shot him. He ain't killed him. Why is he in constant fear and coercion? And why was the AUSA pushed another false narrative? We just went over one about literally taking what Peter to robbing Peter to pay Paul means. That's left for interpretation. But one thing for sure, I could bring my mama and she gonna tell you a better definition and understanding of what robbing Peter to pay Paul say. See, maybe them rich white folks don't understand those type of black man struggles. You know what I'm saying? They jump to conclusions because they want to. Oh yeah, this is nasty work. So now here's the false narrative that he clipped at, that he was under constant fear and coercion. A Frank's review that tests whether these characterizations were misleading and material would place the issue in court in a difficult posture of reassessing and potentially discrediting premises that supported its own earlier decision to authorize the wiretap. Precisely, the circumstance reassignment is intended to avoid. When a judge is asked to evaluate whether they were previously misled by such omissions or distortions, it creates a structural conflict that threatens both the appearance and reality of impartiality. Reassignment ensures that a neutral arbiter, unburdened by prior findings of probable cause or necessity, can objectively determine if the government's affidavit fundamentally undermine the integrity of the judicial process. Okay. The government's tactical case steering created the current procedural conflict. Now they're going after the assistant United States attorney. The present procedural conflict is the foreseeable consequence of the government's deliberate and selective case steering. They're pushing narrative. Although the same AUSA oversaw every prosecution arising from a wide swath of cases arising from that same investigation, they invoked relatedness inconsistently, seeking to relate cases only when doing so ensured consolidation before the very judge who had authorized the underlying wiretaps. The government thereby created the precise circumstances that now trigger Ninth Circuit precedent, requiring that suppression challenges to those wiretaps be decided by a different court. This conflict arose in the context of Operation Drawdown, a years-long, wide-sweeping investigation that resulted in 19 defendants being charged across 11 separate matters, including the instant case, Exhibit A. The United States Attorney's Office for the Central District of California and the Los Angeles Division of the FBI publicly highlighted these arrests and charges, characterizing the defendants as members and associates of the Rolling 60 street gang. Yet, despite the unified investigative origin and common prosecutorial control, the government selectively applied related case procedures in a manner that foreseeably created the current procedural conflict. The pattern of selective relatedness. The government's inconsistent filing of notices of related cases suggests a litigation tactic rather than a commitment to judicial economy. In the earliest stages, the government attempted to relate USA versus Hun inter alia to USA versus Jones. Docket Judge Clausen declined that transfer, finding no facts indicating that the case involved the same parties or same traction or same transactions, events, or occurrences. Following this rejection, the government became highly selective. On October 1st, 2024, the same day the Hun indictment was filed, the government filed USA versus Forbes and USA versus Smith, and 1 week later, USA versus Hughes. Despite these cases originating from Operation Drawdown, the government filed no notice of related case in any of them. Similarly, when the government filed USA versus Green, USA versus Mitchell, and USA versus Britain in February 2025, it again chose not to relate the Green or Britain matters to any other drawdown case. See FBI Los Angeles Division Instagram post announcing arrests and charges for 19 Rolling 60 members and associates as part of Operation Draws Down. Now, mind you, I know a Fruitown Brand member on there. I know I seen an Asian on there. I seen a Russian on there. These are not Rolling 60 members, but they're trying to prejudicially attach Big U to them, right? So they post the link, right? And I'm not going to hit that link. March 19, 2025, United States Attorney's Office, CDCA, did a press release titled 18 Other Rolling 60 Members and Associates Charged Federally. Longtime Rolling 60 Crips leader and show business entrepreneur charged in federal complaint alleging racketeering crimes. U.S. Department of Justice. 2. The Mitchell Forbes bridge to this court. The government's silence on relatedness ended only when it saw an opportunity to pull cases toward this court. On February 25th, 2025, the United States Attorney's Office authored a notice of related case claiming that Mitchell was related to the prior filed Forbes case. The government argued that transfer was necessary because both cases charged firearm offenses arising from the same investigation into the Rolling 60s. And both indictments rely on evidence that ultimately led to Title III wiretap in case 22 CM 221 FLA. And common discovery will be produced. 25 CR 132, docket 7. This court consented to the transfer. ID at docket number 9. So we going to have to go get those, what you call it, and I'm going to take me breaking this down and put them up so that y'all be able to get an edited version of this. You know what I'm saying? But the November 2, 2022 Title III application challenged by the defense, which include a target telephone for Mitchell, make no mention of Forbes. Aside from being part of the same general investigation and takedown, these defendants are no more related to each other than to any of the other defendants in the 9 cases where the government remains silent on relatedness. 3, the resulting structural conflict. The instant matter was originally assigned to Judge Sue, but was transferred to this court only after the government found a notice of related case to the Mitchell matter, right? 25 CR 211 at dockets 90 and 96. But for the Mitchell case being used as a bridge to the Forbes case, this matter would have remained with Judge Scarsey, who was originally assigned to Mitchell. The government's successful effort to steer this litigation to the issuing judge has now created the very structural necessity for reassignment that the Ninth Circuit seeks to avoid. By choosing to consolidate these matters here, the government ensured that the presiding judge would be the same jurist immersed in the ex parte development of the government's investigation centered on a series of wiretap applications that the court issued. Having created this conflict, the government cannot now avoid the procedural remedy. The wiretap suppression motion must be reassigned to a neutral arbiter to ensure an independent second level of review. C, judicial economy favors reassigning the standard warrant motion to the same independent judge. The Fourth Amendment's warrant requirement depends on a neutral magistrate, a role compromised when the government presents a systematically distorted narrative. Here, the overlap between the standard search warrants and wiretap authorizations is not merely thematic, but evidentiary. Both applications rely on a virtually identical factual through line, using many of the same anchor events to construct the government's false theory of extortion. Critically, although the affidavits bear different signatures, the affiants work closely together in developing the investigation, such that the distortions and omissions embedded in each application cannot be viewed in isolation. When factual misstatements are corrected and exculpatory context restored. When factual misstatements are corrected and exculpatory context restored, the shared narrative collapses, revealing that both warrants rest on the same flawed factual core. This shared and distorted narrative, advanced through the efforts of each affiant, must be evaluated collectively to determine whether the misrepresentations were reckless, if not deliberate. Because these suppression motions challenge warrants grounded in the same evidentiary foundation, judicial economy and the interests of justice strongly favor having them decided by a single district judge who did not authorize the underlying surveillance. First, both affidavits rely on the same alleged July 5th, 2021 robbery as the primary predicate for the investigation. So they said both of the affidavits rely on the July 5th, 2021 robbery as the primary predicate for the investigation, right? In both instances, the government, that's big, bro. If that's how they got the wiretaps and to start the FBI investigation was the alleged a weed dispensary, everybody eats weed dispensary robbery, which we all come to find out through what I had already knew, but all come to find out through Hoover Gumby that he recorded Dale Morrison admitting he knew Dale Morrison, and Dale Morrison admitting that Whack 100 paid him to say Big U was extorting and robbing. And then Whack 100 brought Loose Cannon, who was supposed to be an alleged robber, on the phone and recorded it and released it to the internet so that it could be open source intelligence, having him pointing the finger, corroborating what happened with this robbery. He had already talked to the Fed previously too. He said they pulled him over at the gas station, but he had talked to him before that too. So he's talking to the Feds multiple times. Loose Coochie Ashley, Loose Lips Cannon. By presenting this uncorroborated event as a foundational fact in both applications, hold on. In both instances, the government characterizes this incident as an established extortionate robbery. By presenting this uncorroborated event as a foundational fact in both applications, the government created a shared narrative that a single judge should now parse. Adjudicating either motion requires evaluating the same omission, including the FBI's lack of investigation and the confidential human sources' immediate resumption of business with his alleged robbers, including seeking protection from actual robbers to determine if the magistrate was systematically misled. Second, so he done resume, Dale Morrison to resume doing business with his alleged robbers, Big U and Loose Cannon and all of these people that they're alleging did it, including seeking protection from actual robbers. Man, but I need y'all to protect me from actual robbers. You know what I'm saying? To determine if the magistrate was systematically misled. Ooh, now I know why CS2 Back was pointing the finger at that other YouTuber. Damn. Now wonder niggas always running content against Big U. The actual robber. Damn. We ain't doing no snitching though. Second, both affidavits utilized the same December 2nd, 2021 phone call to portray Henley as demanding a $30,000 extortion payment and issuing threats. Each time the government relies on the same cherry-picked quotes to manufacture a narrative of criminal coercion, restoring the context. So they're trying to put this $30,000 demand down. I knew about this too. I knew this was one of the issues the lawyers had talked about, right? Now they didn't put the motion in. Restoring the context of this call, which reveals a routine business dispute over a promotion of Mr. Henley's birthday celebration, a proposal conceived and priced by the confidential human source himself. So Big U is trying to get his money. This nigga done came to agreement. Okay, I'm going to run the party. I'm going to promote it. I'm going to need you to do this and that. Bring T.I. or whoever, Joe Moses or whoever, you know what I'm saying? Get them to perform, and I'm going to bring you 30 bands, right? And so it's your birthday, you know what I'm saying? So Big U said, okay. So you proposed, you conceived and came up with this idea. You told me you're going to give me $30,000 for doing my part, and I did my part. Now it's a task that should not be duplicated across two courtrooms, right? A proposal conceived and priced by Dale Morrison himself is a task that should not be duplicated across two courtrooms. Crucially, the distortions and material omissions of each affiant cannot be viewed in isolation. So you can't just look at these in isolation. We got the court, not this court, we needed to be another court, needs to look down into these as a pattern. And the reason that they're doing it is because they're attacking the integrity or lack thereof of the assistant United States attorney. They're attacking the integrity or the lack thereof of the FBI and their intentions with this investigation, the way that they did it, the procedures that they did it. In fact, the fact that two agents working in tandem recycled the same distorted narrative across different warrant applications demonstrates an overall pattern of deception rather than a series of negligent oversights. So yeah, they going after the agents, steadily putting him as and pushing the narrative that this dude was being extorted when this dude came up with the idea, came up with the price he was going to pay Big U. Big U agreed, and he didn't have his money. Now you owing me $30,000. I'm gonna be hostile and aggressive when I talk to you, nigga, with my motherfucking money, nigga. Nah, nigga, don't play with my money. Don't play with my money. Hey, listen, don't play with a black man's money. You know what I'm saying? That's just what it is. So you just use me, huh? So I'm just a sucker, right? How you be working these other niggas, Peter to pay Paul, you just gonna sucker me in, right? Nah, fuck all that, right? So they're alleging, Big U's lawyers, that the two agents working together, recycling the same distorted narrative across different warrant applications, demonstrates an overall pattern of deception rather than a series of negligent oversights. So that it's a different level, right? That's saying they knew and intentionally deceived, knowing the truth of this because of what we find on a wiretap, where they hear him say, I want to do this, where they must hear him saying, I'm gonna pay you $30,000. Each agents, and that's not what they presented to the grand jury. That's not how they presented it to the grand jury. So it's easy for a grand jury who's been presented this evidence as if he was extorting them without bringing the evidence to prove that this was his idea. That was the price that he gave him. Each agent's decision to foreground the confidential human sources one's uncooperated claims while concealing his proactive business solicitations. So both of the agents decided to foreground. Let me see the legal definition of foreground, because foreground can have legal definitions could be different than actual definitions. It's literally a different language within itself. Let me put legal definition. The part of a view that is nearest to the observer, especially in a picture or photograph. The images show vegetation in the foreground. So let's go legal. See what I'm saying? Legal definition of foreground. So the legal definition, to understand the legal definition of foreground, consider the following points. Foreground refers to the intellectual property created during a project or contract. It typically includes inventions, designs, and works developed using specific resources. Ownership of foreground is often defined in contracts between parties. It contrasts with background, which refers to pre-existing intellectual property. Foreground, oh yeah, that goes in the copyright. I'm gonna do it. Let me put Black laws. Black law dictionary. See how that's 3 different what you call this already? So refers to the part of a scene or image that is closer to the viewer, right? So let's get back to the reading. So each agent's decision to look at it from the perspective closest to the confidential to Dale Morrison's uncorroborated claims, while still concealing his and then they hiding from the grand jury in the court that he had proactive business solicitation, bears directly on the overall recklessness, if not deliberateness, of both affidavits, because the Franks challenges in each motion turn on this collective pattern of behavior. A single independent judge should view these actions collectively. Assigning both motions to one judge ensures a comprehensive evaluation of the government's investigative integrity. I told you they was coming for their integrity. Investigative integrity promotes judicial economy and prevents the risk of inconsistent outcomes regarding the same set of distorted events. So they said that was calculated. The FBI knew what they was doing. The AUSA knew what they was doing. And that's why they kept going to the same judge. Having a single judge decide both motions would also avoid unnecessary duplication of judicial effort, because both motions rely on the same evidentiary record. Mr. Henley filed a consolidated set of exhibits requiring two different district judges to independently review and master these overlapping materials would needlessly consume judicial time and resources. Further, a single judge is best positioned to provide a consistent, comprehensive evaluation of these common factual predicates, ensuring that the government's investigative integrity is measured against the full weight of the restored record rather than fragmented isolation. Conclusion: for the foregoing reasons, defendant Eugene Henley Jr. respectfully requests that the court reassign the motion to suppress evidence obtained from standard search warrants to the same independent district judge that must hear the motion to suppress intercepted communications. The undersigned counsel of record for Mr. Henley certifies that this brief contains 2,434 words, which complies with the word limit of LR Local Rules 11.6.1 and the word limit set by the court standing order dated October 1st, 2024. That's Craig Harbaugh. Good motion by Craig Harbaugh. Peter Johnson, attorney for Eugene Henley Jr., man. Shout out draws, Operation Drawdown. So here's the targets that they made sure they put everywhere. You know what I'm saying? Look, you got Fuak Keong Hong, right? Brian Enrique Perez Mejia. These are 60 Crips. I know Denavian Hughes ain't. That's the homie. That's the homie out the Fruitown Brim. And then I don't even know who the other people. Zachary Garcia, right? Joshua Pilatihalla. Are those all rolling 60 Crips? I don't believe so. So we finna run this other video, and after I do that, we gonna end it 49 minutes in. That's not bad. That'll give me a break, and then we got two more motions we gonna pre-record, and tonight we'll be going live. You know what I'm saying? You know what I'm saying? So let me give y'all this real quick. $504. Wait, where did I put that video? I should have it already. Oh, there it go. Boom. Let's get to it. Shout out my guy. Sweetport. Let's go. Where we at? He said Big U is a rat.
Drive to bring it
Federal
to life.
wire transcripts finally
Describe
hit
what
the
you want.
internet. Let's get to it then.
Eugene Henley Jr. has become known in recent years for his charity work to reduce gang violence. Now the FBI is accusing him of running a criminal enterprise that committed a series of crimes.
I just need y'all prayers. Need y'all to... I don't even know what to say.
Remember Big U? He turned himself into federal custody after a shocking indictment alleged he committed a number of crimes.
And here we go. Apparently, I'm Big U lawyer now. That's what I've been told. Soon as you correct something, suddenly is why you defending him. Defending him from who? The YouTube Supreme Court already broke down the superseding indictment nonsense, already explained stacking a deck, already explained how pressure tactics work, already walked through how federal cases expand when somebody refuses to fold. And now I'm back again, knocking already head. Oh, he back, he riding, he must know something. Yeah, I know how federal procedure works. That's what I know. And this next part, y'all ain't gonna like it. Because now we stepping into that wiretap fairy tale shit. The one that said Big U knowingly used the tap phone line to line people up for the feds. Yeah, that one, the dramatic one. Does this sound good in the thumbnail one? Like, slow that shit down, bruh. So you telling me a man allegedly running major operations knowingly used a federal wire to secretly help the government, and the government just didn't mention it? You see how wild that shit sound when you say it calmly? If that were true, it would be the whole headline. Long time informant exposed. Gang leader secretly cooperating. Double agent indicted. That's how indictments work, homie. Government does not hide betrayal narratives. They highlight them. They weaponize them. They use them to inflame juries. Because nothing threatens a prosecution like betrayal, breach of trust, secret cooperation. Man, that's courtroom gold right there. So why is there zero mention of it? Not buried, not hinted at, not even implied. Zero, bruh, zero. Because it didn't happen. Let's get surgical on these bitches. If someone knowingly used a telephone for years to feed information, why file a motion to suppress the wiretaps? Why try to throw the recordings out? A motion to suppress is filed to block the government from using these calls as evidence. If your whole story is I was helping them, you don't try to bury the tapes. You play the tapes. You let the jury hear them. You say, see, I was a good guy the whole while.
You know it's 26,000 wiretaps, right?
Yeah, he's got a lot of phone calls that have been recorded.
What would you say if the same phone and all your socials is named and the Sue Surf wrote New Jersey Rolling 60 indictment in 2021? You are target number 4, Big U Eugene Henley, gang leader supplying drugs and guns to the New Jersey Rolling 60s from Los Angeles. And yet for the next 4 years, you stayed on the same phone calling all your homies.
Cap.
Stop it. Get some help.
Instead, suppression motion. Why? Because the defense is attacking the legality of the wire. Under Title III, the government has to prove necessity. They have to show how they tried other investigation methods first. If they were lazy, if probable cause was weak, if the affidavit had problems, if they failed to minimize unrelated cause. That wire can be challenged. That's federal procedure. So again, bruh, why would somebody who knew for years their phone was tapped try to suppress the very evidence they supposedly created intentionally? You can't explain that shit at all because it collapses the lie. Here's another fact that somehow gets ignored. The moment it became known the phone was tapped, usage changed. Big U used other phones to contact his wife. That's documented. That's in the government factual basis. That in itself is behaviorship once he found out. That's reaction once he found out. If you knowingly feeding information through a tap phone for years, why switch once it's exposed? Why stop using it? That contradicts the very fantasy that they use to create the lie, because the fantasy requires long-term knowledge. But Big U's conduct shows adjustment once awareness happens. That's not cooperation at all. That seemed like damage control to me. Here's something else. If someone was an active informant, who went bad or exceeded authority. The government would have absolutely led with that. It wouldn't hide it and surprise everyone in that trial. They would have framed it in the indictment, a post-detention memo. They'd say he abused his informant relationship. He breached trust. He operated as a double agent. That strengthens their narrative. Prosecutors don't leave leverage sitting on the table, ever. Now let's shift to that developing options nonsense. These dudes on the internet claim that his nonprofit was secretly used to set up gang members for arrest. That one there sound more dramatic than a Martin Scorsese film, except there's zero mention of that in the indictment.
That's the phone that he got.
Yeah, that is named in the contract. 7th Street Division issued him a BlackBerry as a police issue phone to report all gang violence in his grid area. And this is an annual contract. If he doesn't produce, then they take it. He been out with a contract too.
No, they don't take it. First, the grid is from the federal. The grant that Big U got comes from the mayor. But the grid puts in, I think, 250,000 just so they could claim jurisdiction and make people snitch. Big U refused to snitch. And that's one of the reasons that's in this paperwork. But this is the lie and narratives that these dudes kept running on Big U, and y'all supported it. No Jumper should be writing a check to Big U right now. They lucky I'm busy with my business, because if I didn't have no chance to help gross $1 trillion with this app, I guarantee you, nigga, I wouldn't have had nothing better to do than to file that civil suit myself and get my motherfucking cut. Let's go.
11 years. He did such a great job. He went from $550,000 a year. They gave him a $440,000 bonus. We send the contract. But listen, fuck all that.
Cuz is actually putting us in paperwork, right? And like doing like real police shit. I seen the nigga get like 20 guns, and when he got 20 guns, he's selling them to the homies. But I'm like, why are you writing down the serial numbers? So it's like he was doing like shit like that, and I didn't catch on. So it was like, I'm waking up now. You get what I'm saying?
The grid program does not require, let's get back to that, right? The grid program does not require, and we finna get back to it. Hold on. The grid program does not require nonprofits operating its call lines or intervention programs to get people arrested, charged, or convicted. In fact, the program is largely designed to do the opposite. Prevention. Prevents mean before a crime exists. Prevent violence before violence exists. Prevent violence and reduce involvement with the criminal justice system. So we could, I should have been put that through Chat GPT. Let's do that real quick, right? Does the federal grid program make nonprofit organizations feed information to LAPD or law enforcement about crime, about crimes and gang activity? Let's see what they say. So it says, no, the GRID program does not officially require nonprofit organizations to act as informants for LAPD or report crime. However, there is coordination and information sharing between community organizations and law enforcement in certain situations, which is where the controversy often comes from. Here's the accurate breakdown. What the GRID program actually is: the Gang Reduction and Youth Development Program was created by the LA Mayor's Office in 2007 to reduce gang violence through prevention, intervention, and community programs like the football, Intervention means to intervene. You know what I'm saying? Before it happened. And prevention means prevent before it happened. It utilized community-based nonprofits to run programs like youth prevention services, gang intervention, and violence interruption. Hey, nah, bro, y'all not finna be doing graffiti over here in the hood and this and this and that. Y'all got to stop that. Case management for families. Community programs like Summer Nights Lights. The goal is to address root causes of gang involvement and improve relationship between communities and law enforcement. Do grid-funded nonprofits have to report crimes? No law or program rule requires nonprofits to report crimes to police or act as informants. Their contracts mainly require program reporting, attendance, services delivered, spending, and outcomes. Case management documentation for youth and families, quarterly and monthly program reports to the city, right? These reports are administrative, not criminal intelligence reports. Where the confusion comes from, the grid strategy intentionally coordinates community groups and law enforcement, which mean community organizations, intervention workers, social services, LAPD, all work within the same violence reduction system. The program explicitly aims to increase information sharing and coordination among community groups and law enforcement to prevent retaliation after violent incidents. That does not automatically mean confidential information about participants is given to the police, but collaboration happens during crisis response or violence interruption situations. If there's a shooting, they get the family back, get back up, don't crowd them, don't touch them, don't lift them, so the paramedics can do their job. If the person dies, they give them all of the resources that they need, where the body's going to be going, who could coordinates how they could pick up the thing, and they work with the family, not the police. You know what I'm saying? Confidentiality rules for participant. Most grid service providers operate under social service confidentiality rules, meaning they generally cannot disclose client information without consent, except for typical legal exceptions, such as imminent threats of violence, child abuse reporting, court orders. This is similar to rules used by social workers and counselors. Real criticism and community concerns. Some activists and gang intervention workers have historically raised concerns that close cooperation with LAPD could blur the lines between community intervention and policing. Trust with gang-involved youth could be damaged if they believe workers share information with police. These concerns are part of ongoing debates around violence reduction programs nationwide, but they are not required to feed intelligence to the LAPD. So that narrative is already hit. Now, I'm quite sure they got some grid workers that is working with the police, but that just means they were snitching before. Y'all hoods, each one of y'all got niggas in y'all hood feeding information to the police. You know what I'm saying? But y'all ain't brought the paperwork on there one grid worker yet. You know what I'm saying? Let's go.
If a nonprofit was the front for assisting law enforcement to entrap people, that would be explosive. That would be headline material. Anti-gang nonprofit use a criminal front. That makes the case stronger. That paints motive. That paints deception. That influences jurors. And yet, nothing, not a sentence, not a paragraph, because them shits is fiction, bruh. Developing Options is a documented nonprofit that began in 2004, focused on youth intervention in the 77th grid zone. You can dislike the man, you can question the organization, you can even critique outcomes, but you cannot invent a federal conspiracy narrative with zero documentations to back it up, homie. That's not analysis at all. That's fake fake storytelling to push a false narrative. And this right here is what's really dangerous. Once these stories get repeated enough times, they start sounding real. Not because they support it, but because they're dramatic. And drama spread faster than procedure. But federal court don't run on drama, bruh. It run on filings, affidavits, statutes, motions, standards, and logic. You can bash the man all you want. You can even lay up there and critique his case. You can debate the charges. Once you start manufacturing informant fantasies, that collapse under basic procedure. Review. Now you not analyzing, you speaking on open cases trying to slander the man. So who really the police? I'll wait. And there's a difference. This isn't about defending Big U at all. It's about cleaning up narratives that don't survive 5 minutes under federal law logic. Because once we allow dramatic lies to replace documented process, nobody's safe from internet indictments. And that's the real issue.
And I hesitate to even open this can of worms, but we have reason to be skeptical about your statements about Big U because you obviously co-signed loose cannon telling the story about how Big U basically got Nipsey killed or whatever.
We never said he got Nipsey killed.
Okay, but you're saying that he had premeditated knowledge that Nipsey was going to get killed.
What he's saying is...
And that didn't really pan out, although a lot of people are now looking at those statements as if they might have a lot more validity than they once thought.
Let's get into this part that people keep skipping over because it requires thinking. Wiretaps are not casual. They are not. We think he might be talking. Let's just listen. Federal wiretaps fall under Title III. That means judges don't just rubber stamp them because somebody acts nicely. The government has to submit an affidavit. That affidavit has to lay out probable cause. Why traditional investigative methods fail. Why undercover agents weren't enough. Why search warrants weren't enough. Why surveillance wasn't enough. Why informants weren't enough. Listen to me again. Affidavit has to lay out probable cause. Why traditional investigative methods fail. Why undercover agents weren't enough. Why search warrants weren't enough. Why surveillance wasn't enough. Why informants weren't enough. Let's slow this whole made up fairy tale shit down. If Big U was knowingly using a telephone to line people up for the feds, why would the government need a Title III wiretap in the first place? That shit don't make sense. Why would they all get necessity? Why would they say we tried everything else and it wasn't enough? You don't wiretap your own cooperator just for shits and giggles. You debrief them. You put them in the room. You build cases through profit. You don't secretly record them for years hoping they help you. That's not how this shit works. The wiretap statute literally requires the government to show that other methods fail. So if somebody was actively helping, that destroys necessity. And if necessity fails, the wire fails. You see how the lie collapses once you apply actual logic and procedure? Now let's just talk about how wiretaps actually move. When a wiretap is authorized, it's for a limited period, usually 30 days. After that, they have to go back to the judge and renew it. And in those renewals, they have to show progress. They have to show what they gathered. They have to justify continuing surveillance. If someone knowingly cooperating on that phone, that would appear in the narrative. It would change the tone of the renewal because now the government isn't trying to uncover unknown activity. They're documenting a relationship. And again, none of that appears. Now let's get into minimization. Under Title III, agents are required to minimize, meaning if a call is clearly personal, clearly unrelated, clearly privileged, it's supposed to stop listening. So when you hear the idea that someone was just casually using a tap phone for years to feed the feds information, understand something. That will require coordination. That will require documentation. That will require an established cooperation framework. And cooperation frameworks are not hidden once indictments drop. They are exposed because prosecutors use that to frame the motive. See? He was playing both sides. That's powerful language in court, bruh. And yet, silence. No breach of trust narrative. No double agent storyline. No confidential source turned rogue. Nothing. Now let's deal with this timeline shit. The moment awareness of the tap becomes clear, Big U behavior changes. That boy phone changes. Communication routes change. That's not the action of someone intentionally feeding information. That's the action if someone realizes surveillance is active. If you knowingly using a wire to assist law enforcement, you don't pivot away from it once it becomes public. You don't scramble. You don't adjust. You just continue because the whole time it was part of your strategy. So the story that these dudes selling on the internet requires you to believe, one, Big U knowingly used the tap phone for years. 2, the government never mentioned it. 3, the indictment omitted it. 4, the detention memo omitted it. 5, suppression motions were filed anyway. 6, Big U's behavior changed once exposure occurred. That's not a theory. That's big time contradiction. The moment people start saying he knew the whole time, they're not just speculating. They're accusing someone of being a federal informant. That's not a small allegation. That carries weight. That carries street consequences. That carries reputational consequences. And you better have documentation when you say it, because in prison, you're going to get killed or run up top, period. In the streets, the game has changed so much, they letting these rats live. Some they even make famous. I swear, bruh, you can't make this shit up. It's like I said, no, I heard this. No, I heard that. No assumptions. You need documentation, paperwork, and not no docket sheet either. And if any of the bullshit that they're saying really existed, it would be in the charging documents, because the government does not sit on leverage. They stack the deck. They lead with what hurts. And if there was a betrayal angle from an informant, it would be front and center. Instead, we have wiretap challenges. We have suppression motions. We have procedural battles. That's what's actually happening. Understand something. Federal wiretaps are technical, structured, judicially reviewed, and strategically used. They are not YouTube plot twists, homie. Oh, did you see what he said about the Nipsey on wiretap shit? And when you understand that, the fairy tale starts looking exactly like what it is, a fairy tale. Man, y'all dude be saying anything and believing any of this old dumbass shit this dude be saying on the internet. That's how indictments are structured. They tell a story, they build narrative, they create betrayal scenarios, and that shit they saying online will be the biggest betrayal scenario possible. And yet, silence, because it doesn't exist in the record. And here's where it gets dangerous. People are confusing community intervention with federal cooperation. Those are two completely different things. Working to reduce gang violence in the city is not the same as secretly feeding law enforcement targets. One is social programming. The other is criminal informant behavior. Those are not interchangeable, bruh. Now let's be real for a second. If a nonprofit was secretly operating as a pipeline to help convict gang members, that wouldn't stay hidden for years. Not in Los Angeles, not in that environment, not with those dynamics. Somebody would expose that shit a long time ago, because that type of betrayal just not stay quiet. And the government would absolutely document it in a high-profile indictment because it helps them. Always remember that. If something makes the prosecution stronger and it's missing, there's usually a reason. Now let's circle back to the bigger issue. People start inventing law enforcement conspiracy narratives with zero documentation. They're not analyzing a case. They build the drama that can potentially hurt that man's case. And drama travels fast on the internet.
This is the most anticipated smart security camera of the year.
Let's get back to the content. Bang that like button. My
And
boy
it sounds
bringing
explosive.
it
Now here's what's really happening. There's a case moving through federal court. There are suppression motions. There are conspiracy allegations. There are superseding indictments, which we already broke down as a pressure tactic when someone refuses to cooperate. That's the battlefield, not secret nonprofit spy operations, not double agent fairy tales, actual procedure. And once you understand how federal prosecutors build cases, you stop falling for the dramatic side stories that don't show up in the paperwork. But because paperwork wins in court, not some dude imagination on the internet. Now let's close this one here out the right way, because at this point, it's not even about Big U. It's about discipline. It's about how reckless people get when the federal case hits the timeline. Everybody turns into an expert overnight. Everybody suddenly fluent in conspiracy law. Everybody decoding indictments like it's rap lyrics. Everybody building narratives off vibes. And the wild part, most of the damage ain't even coming from the government. It's coming from the commentary, from people who don't understand the grand jury actually is, how witnesses get subpoenaed, how secrecy works, how stacking the deck functions, why superseding indictments appear, what suppression motions mean, how Title III wiretaps actually operate. Instead of saying I don't know, they fill in the blanks, and filling in the blank in any open case is dangerous, because once you say somebody knowing and use a tap phone to line up people, you calling them an informant. That ain't small at all. That ain't light. That ain't entertainment. That shit heavy. And if you don't have documentation, you gambling with somebody's name. You gambling with your own life. Now let's clean this up one more time. Simple. If he knew the phone was tapped for years, he wouldn't move to suppress the wiretap. If he was secretly feeding information, government would have highlighted that betrayal. If the nonprofit was a set-up pipeline, it would be in the indictment. If he was cooperating, it wouldn't be stacking the deck when he's talking about going to trial. None of these pieces align with the lie they saying on the internet. In federal court, is about alignment, documents aligning, statements aligning, procedure aligning, not storytelling and fake bullshit. Now here's the deeper issue. People think federal cases move like street politics. They don't. They move like chess, slow, layered, strategic, methodical. Feds don't need drama. They don't need plot twists. They don't need cinematic portrayal stories. They need evidence that survives in court. That's it. And when someone refuses to cooperate, they escalate, they tighten, they apply pressure. That's not mysterious at all, homie. That's mechanical. So when you see the superseding indictments, that's not some seeking information revealed. That's pressure. When you see wiretap challenges, that's defense strategy. When you see suppression motions, that's procedural combat, not double agent behavior. Here's the part people gotta sit with. You can dislike the man. You can think he guilty. You can think he innocent. That's your opinion. But once you start manufacturing cooperation narrative without paperwork, you cross from commentary into fiction. And federal fiction is dangerous because federal court does not care about your narrative. It cares about what can be proven. And until trial unfolds, until motions are ruled on, until evidence is tested, everything else is just noise on the internet. This whole situation exposed something bigger though. People love feeling like insiders, love thinking like they crack something, love believing they see what nobody else sees. But real federal procedures is not flashy, it's technical. It's boring to people who want drama, and that's why the dramatic lie spreads faster than the procedural truth. Because truth requires patience, and patience don't trend. So let's keep this here clean. This wasn't about defending Big U. This was about correcting the nonsense bullshit going on the internet. There's a difference. You don't have to cheer for somebody to demand accuracy. You don't have to like somebody to reject a lie. And if you really care about justice, you don't let information run wild just because it sounds good. Because today it's him. Tomorrow it could be anybody. Tomorrow it could even be you, partner. And once we start normalizing inventing federal narrative with zero documentation, we all one rumor away from conviction in the court of public opinion. That's the real issue, not the indictment, not the wiretap, not the nonprofit. The commentary, clean that shit up, bruh. Don't speak on it at all. You heard me?
You heard me? She.
Got your ass.
Got your ass. CS2 back. So I'm gonna end this one and start this off good. I talked to Big U not last night, not the night before. Yeah, the night before last. Or was it the night before that? The last 2 days, right? This might be the third day. And Big U told me, he can't talk. This is some real life COINTELPRO shit going on, right? So I want y'all to know that. Big U told me that this is some COINTELPRO shit going on. So he cannot talk about his case. You know what I'm saying? He cannot talk online because whatever he says, they're going to weaponize it against him and flip it. Everything comes with a yin and yang, so you can have good intentions and say something just like on this one where he says, well, we're going to rob Peter to pay Paul. And they took that to try to flip it to say he was actually talking about robbing somebody, right? So he has no statements to make but this statement about WAC 100. See, he became horny. Pause. He was excited. Pause. When he got word that CS2 back said that he was going to sue him. He said, that's what he ain't going to do. He said, do he know I get to depose him? When did you become an FBI agent? When did you start working with the federal government? What cases have you worked in? He said, this would be the greatest joy he ever had. He looks forward to it. So until we get to the next filing, I think we got the government's filing and we got another Big U filing, and I think they were ruling on them today. So hopefully I'll get word or updated word about what's going on. But yeah, CS2 back challenges you to file a lawsuit against him because he's going to depose you, and that deposition will be released on the DAMU KIWE Conversation. We out of here. Let's go. I'm going to get this to y'all ASAP. Let's go.